Hello guys. IPOB leader Nnamdi Kanu has called for extension of time to appeal 2021 ruling that ordered his detention. Barrister Loy Ejimako, who is a special counsel to Kanu, made this known on Thursday. He said that the detained IPOB leader, who was rearrested in Kenya in June 2021, was secretly presented in court on June 29, 2021. So guys, welcome back to Prospect Channels TV. Thank you for this coming out here. The detained leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, has filed a motion on notice application at the Court of Appeal, Abuja, seeking an extension of time to appeal the judgment of the Federal High Court that ordered his detention in June 2021. Barrister Ejimako, the special counsel to Kanu, who made this known on Thursday, said that the detained IPOB leader, who was rearrested in Kenya in June 2021, was secretly presented in court on June 29, 2021. Ejimako said the court secretly held a hearing and ordered him detained. All these were done without notice to his counsel, who was well known to the court. This is unconstitutional. In the application by Kanu's legal team, led by Ejimako, Kanu, who is the applicant, prayed the appeal court for an order extending the time within which he may appeal against the criminal proceedings and the order of remand or detention made therefore by Justice Binta Nyako of the Federal High Court in June 29, 2021, in charge number FHC/ABJ/CR/383/201 between him and the Nigerian government. He noted in the application that he is applying for an extension of time to file his appeal because the time for the appeal has elapsed. The application further stated, take notice that the applicant, being dissatisfied with the decision of the Federal High Court sitting in Abuja, contained in the ruling of His Lordship Honorable Justice Binta M.F. Nyako, delivered on 29th day of June 2021, in charge number FHC/ABJ/CR/383/2021, more particularly set out at paragraph 2, do hereby file his proposed notice and grounds of appeal to the Court of Appeal upon the ground set out of paragraph 3, and will, at hearing of the appeal, seek the reliefs set out in paragraph 4 of his notice and proposed grounds of appeal, and take further notice that the names and addresses of persons directly affected by the appeal are those set out in paragraph 5 of the judgment. So he noted in the application that he is applying for an extension of time to file his appeal because the time for the appeal has elapsed. The application further stated, take notice that the applicant, being dissatisfied with the decision of the Federal High Court sitting at Abuja, contained in the ruling of His Lordship Honorable Justice Binta M.F. Nyako, delivered on the 29th today of June 2021. And take further notice that the names and address of persons directly affected by this appeal are those set out in paragraph 5 of the judgment. The applicant noted that the grounds of the application include the learned trial judge held in law when his leadership denied the applicant fair hearing in the proceeding conducted on 29th day of June 2021 which gave rise to the ruling order upon which the applicant is remanded and contained from 2029 June 2021 to the day. The said proceedings which were conducted and which led to the detention, remand of the applicant was conducted without the applicant being held and being committed to the custody of the complainant respondent instead of a prison, in violated of the provisions of section 196 of the Administration of Criminal Justice Act 2015, which provides that where a defendant has been admitted to bail and circumstances arise which, in the opinion of the Attorney General of the Federation, would justify the court in cancelling the bail or requesting a greater amount, a court may, on application being made by the Attorney General of the Federation, issue a warrant for the arrest of the defendant, and after giving the defendant an opportunity of being heard, may commit him to prison to await trial or admit him to bail for the same or an increased amount, underlying as for phrases. The applicant sought an order allowing the appeal and setting aside the order of remand of the applicant made by the Federal High Court, Abuja, the Judiciary Division. His Lordship, Honorable Justice Binta Inyako, alongside the proceeding of 29 days of June 2021, an order admitting applicant to bail for the same amount he previously was granted bail or for an increased amount. In this alternative, the applicant sought an order setting aside the commuter of the applicant to the custody of the applicant at the State Security Service and instead committing the applicant to prison custody. So guys, what's your take on this?